In some last months in India, the very hot topic was the advocates' agitations against the Advocates' Amendment Bill of 2025, which was ultimately withdrawn by the central government on the last of February 2025. So, in that connection, we would like to discuss about legal profession. So, what exactly it means and how it originated and developed in India in context with reference to the Advocates Act 1961 and those rules framed by the Bar Council of India and also by some state bar councils in Indian states. So, for the very meaning, we would like to examine the very article of Professor W.J. Goody, and that is community within a community. So, Professor W.J. Goody of Columbia University expressed that a community of professionals is different from other communities based on socialization and social control and client choice or the evaluation of professionals. Further, the process of professionalization is the climax job pattern of occupational environment, and no occupation becomes a profession without antagonism and struggle. And also Professor Upendra Bakshi of Delhi University rightly observed that legal profession is often distinguished from other occupations and business for its exclusive learning and scholarship. And as a profession, it oriented to the achievement of conditions of justice in society. And with reference to that, the first law commission after independence and its 14th report in 1958 under the very head of reforms of judicial administration expressed that the legal profession is an important part of the machinery for administration of justice. Without well organized profession of law, the courts would not be in position to administer justice effectively, as the evidence in favor or against the parties to a suit cannot be properly marshaled, facts cannot be properly articulated, and the best legal arguments in support or against the case of the parties cannot be put forth before the courts. Profession of law implies scholarship. As legal profession is an important part of legal administration, therefore the Fifth Law Commission or the First Law Commission after independence in its 14th report in 1958 rightly said that a well organized system of judicial administration postulates a properly equipped and efficient bar. And with reference to that, the Constitution of India under Article 19 provides the freedom to carry out the profession, and which is further given sanction under the Advocates Act 1961, but as it is an elitist and noble profession, so the ultimate aim is commitment to the society and the people. No doubt learning and scholarship is central to the profession of law, but without professional integrity and commitment to serve the community, the profession will lose its novel and elitist criteria. So now we would like to discuss the very development of the profession, and that we would like to discuss under four phases. One is the first, the Hindu period, and in regards to that, Professor Ludo Roker of University of Pennsylvania, in his article Lawyers in Classical Hindu Law, expressed that Valmiki Vasho, Vasishta, Gautama, Kapila, Manu, and Janak, the most famous lawgivers of ancient India. Manu, Janak, Sri Ram, Sri Krishna, and Yudhishthira were the famous rulers come lawgivers. Most famous codified laws were the Ramayana, the Mahabharata, the Upanishads, Manusmriti, and Kautilya's Arthashastra. Justice was delivered to the community and to the society at large with due reference to these codified laws during ancient India. The true interpretation, use, and application of these of them were the responsibility of the then Hindu Pandits, Purohits, Rishis, and Brahmins attached to royal courts. This system of delivering justice to the masses was rampantly prevented till the advent of Muslim rule in India. So, it will be wiser or what to consider those Hindu Pandits, Purohits, Rishis, and Brahmins as the first and foremost legal professionals. In ancient India, these Pandits and Purohits were highly cultured and were having the required depth in learning and scholarship. Therefore, in ancient India, the system of administering justice was most effective and efficient. In spite of an effective justice delivery system, they were not organized as a group of professionals and were not exclusively dealing with legal matters only. Due to their diverse and multifunctional roles in the society, they could not constitute themselves as an exclusive group as it is today. And now we would like to discuss the development during the Muslim period. And in regards to that, Professor Phyllis Calkins of University of Chicago, in his article in Note on Lawyers in Muslim India, expressed that Mohammedan religion had developed during the 7th and 8th century in Arab and gradually spread it to different parts of the world within another 2 to 3 centuries, and with Arab invasion of Sindh, it spread into the subcontinent of India. Around 12th century, the Holy Quran, Ahadith, and Sunnah are the codified laws among the Muslims. Prophet Muhammad during his lifetime was applying the rules of Quran while administering justice. It was continued by his most faithful disciples after his death. Most of his practical methods of application of Quran were compiled later on by his disciples in the form of Ahadith and Sunnah. Consequently, the different Muslim rulers mostly avoid these rulings. Those who were having wide knowledge, learning, and scholarship became muftis, mullahs, ulemas, and qazis. These religious experts had the responsibility in the proper way while delivering justice to the Muslim litigants. Like Hindu scholars, these Muslim scholars were not organized as a group of professionals and were considered as only religious scholars and experts as their Hindu counterparts. And now we would like to discuss the development of legal profession during the British period. With advent of Europeans and their settlement in India and the ultimate British rule led the foundation and beginning of the present day legal system and legal practice in India. The Portuguese and the French influences was very limited towards the development of present day judicial administration and legal profession until 1773. The state of affairs of legal profession as under the charter of Queen Elizabeth I was in a chaotic condition due to the notion and belief of the East India Company that the advocates foment disputes and litigations. The first real step in the direction of organizing a legal profession in India was taken under the Regulating Act of 1773. A Supreme Court was established at Calcutta, and Clause 11 of the Charter empowered the court to approve, admit, and enroll such and so many advocates and attorneys as they shall seem fit. The advocates entitled thus to appear were only the English and Irish barristers and members of the faculty of advocates in Scotland. The same powers of the enrollment were later conferred on the Supreme Courts established at Bombay and Madras. An Indian lawyer had no right to appear before the courts due to the personal initiative and effort of Lord Cornwallis, the then governor of Bengal. The Bengal Regulation of 1793 was issued under Clause 7th of the regulation. Hindus and Muslims were allowed to enroll as pleaders in Sadar Diwani Adalat, but these ignorant and creditless vakils who followed the profession only for livelihood had led to confusion and delay. The justice delivery system and the profession both thus slipped into inefficiency and became too costly for litigants. The Bengal Regulation of 1833 was the next important legislation which modified the provisions of the earlier regulations. Under Clause 12 of the regulation, only persons duly qualified to whatever nationality or religion they might belong could be enrolled as pleaders at the Sadar Diwani Adalat. A number of rules were laid down to regulate the profession, and the professional respectability was hard to come by. To remove the difficulties, the Legal Practitioners Act of 1846 was enacted. The important provisions of the Act, namely the office of the pleaders, were thrown open to all persons of whatever nationality or religion. Secondly, attorneys and barristers of any of our majesty's courts in India were made eligible to plead in any of the Southern courts. And thirdly, the pleaders were permitted to enter into agreement with their clients for their fees for professional services. Next in line, the Indian High Courts Act of 1861 authorized the High Courts to approve, admit, and enroll advocates, vokils, and attorneys. In 1863, another act called the Legal Practitioners Act was enacted, and it permitted barristers and attorneys of the Supreme Court to be admitted as pleaders in the courts of the company, while Indian legal practitioners could not appear before the Supreme Courts. This was a deliberate design to divide and rule and carrying out the policy of racial discrimination. So, in course of time, other high courts were established, and the Legal Practitioners Act 1879 was enacted to consolidate and amend the law relating to legal practitioners of high courts. In the Act of 1861, apart from attorneys, two other classes of lawyers such as advocates and vakils were included. In Bombay, law graduates of the Bombay University, and in Madras, a law graduate. He passed an examination in procedure and underwent practical training with a practicing lawyer for a year could be enrolled as advocates. Under Section 6 of the Act of 1879, the High Courts were empowered to make rules as to the qualification, admission, and certificates of power of persons to be pleaders and muktars of the subordinate courts. Under Section 4, an advocate or vakil on the roll of any high court to practice in all the courts subordinate to the court. This power did not extend to the original jurisdiction of the High Court in a presidency town. The barristers of England, Ireland, and advocates of Scotland were only entitled to appear and plead on the original and on the appellate side of the Calcutta High Court and subordinate courts. The vakils of the Calcutta High Court were not entitled to act or plead on the original side or in appeals from the original side. The same situation was in practice in the High Courts of Bombay and Madras. In 1886, the Madras High Court permitted vakils to appear and plead on the original side. This monopolistic and discriminatory state of affairs, however, later changed, and non-barristers, on passing an examination conducted by the High Court, became eligible for enrollment as advocates entitled to appear and plead on the original side. This monopolistic and discriminatory situation forced the vakils to demand for creating an all India bar to remove the distinction that existed between barristers and vakils and the social privileges enjoyed by the British barristers and attorneys. Consequently, the Government of India in 1923 constituted the Indian Bar Committee under the chairmanship of Edward Chamier to examine and recommend suitable measures, and among those recommendations were a single grade practitioner entitled to plead should be established and called advocates in all high courts. And the second recommendation, the only restriction on the grade of legal practitioners be met, and which should consist of advocates entitled to appear on the original side and advocates not so entitled. And the third recommendation of the Edward Chamier Committee was subject to fulfilling certain conditions. Vakils would be allowed to plead on the original side of the three high courts. And the fourth recommendation was that a bar council be constituted for each high court having power to inquire into matters calling for disciplinary action against a lawyer. And the fifth recommendation of the committee was that the disciplinary powers would rest with the High Court to take any action against a lawyer. And finally, the Indian Bar Council Act 1961, 1926 was enacted by the central legislature, and it provided a bar council for every high court. Every bar council was to consist of 15 members, of whom one was to be advocate general, 4 persons to be nominated by the high court, and 10 persons to be nominated by the high court from amongst themselves by the advocates. Each of advocates of high court have to prepare and maintain a role of advocates. By the High Court, the Bar Council was authorized to make rules to regulate the admission of persons to be advocates, but again, this was restricted with the previous sanction of the High Court, and the High Court was having the discretionary power to refuse admission to any person. So the Act of 1926 merely constituted a bar council for each high court, while the powers regarding admission and enrollment of advocates and disciplinary power were exclusively with the high courts. To prescribe qualifications and laying down conditions under which the advocates were to be entitled to practice or plead again were with the high courts. The act also did not bring the pleaders, muhtars, and revenue officers practicing in the Mafsuli courts under its scope and jurisdiction. The Bar Council constituted under the Act were neither autonomous nor had any substantial authority. This created dissatisfaction and disgust among the Indian advocates and demanded for an unified all India bar with exclusive and independent powers over the advocates and distinctions between barristers and non-barristers. In response to this persistent and widespread demand by the legal community, the Government of India in 1951 appointed an All India Bar Committee under the chairmanship of Justice S.R. Das of the Supreme Court. And those important recommendations of the committee were creation of an All India Bar Council and State Bar Councils. A State Bar Council should maintain register of all existing advocates, all vakils and pleaders being law graduates or not should be included in the role of advocates maintained by the State Bar Council. All vakils and pleaders practicing in the district and other subordinate courts should be enrolled as advocates. The role of advocates maintained by the State Bar Council must be sent to the All India Bar Council to comply a common role of advocates. Further, new law graduates may be enrolled as advocates but restricted further entry of non-graduate pleaders and muhtars into the role of advocates. Finally, the committee's recommendation also viewed in favor of an advocate in any state role to practice in all the courts in the country from the highest to the lowest. So the Law Commission's 14th report in 1958 under the head Reform of Judicial Administration under the chairmanship of Justice S.R. Das as the head of the committee. The commission favored the division of the bar into senior advocates and advocates, the seniors being by reason of their status are excluded from accepting certain types of work. To the seniors, it will mean the recognition of a successful at the bar with an honored position among the members of the profession and enable them to concentrate on important works. The Commission emphasized the principle of autonomy of the bar in matters relating to the profession and also favored the procedure and method of election for the office bearers of the respective bar councils and the All India Bar Council. In consequence to the observations made by the Law Commission and in view of the recommendations of All India Bar Committee's 1953 report, the Parliament of India in 1961 enacted the Advocates Act of 1961. So, further, as we found, these are the important developments made since the practice of legal profession in an unorganized way by the Hindu Pandits, Rohits, Rishis, and Maharshis during the ancient period in India, and how it also developed during the Muslim rule in India. Even those Muslim muftis, ulemas, qazis were unorganized as a legal professions. And further during the British period, how the very origin and development of the present day legal profession was started, and consequently how it led to different acts and regulations by the Britishers, and finally the Indian Bar Council Act of 1926, and after independence the government of India established the Justice S.R. Das Committee in 1951, and the very recommendations of the committee led to the enactment of the Advocates Act 1961 by the Indian Parliament.